Good morning, all, and today's video it's again a Neurotranslator video on a misinterpretation that happened to me at the United States District Court level in Tampa, Florida, coming out of misinterpretations of my autistic language. It happened in the United States Bankruptcy Court in Tampa. So the background of this, what happened was we had been sold a horse farm by this person named Darlene Baylor, and as it turned out, she never transferred title to the mobile home on the property to us, even though she agreed to in the purchase sale contract. And ultimately, we had an appraisal done, and the appraisal said, well, she needed to do a reformation count because the deed was defective, the warranty deed by which she transferred the property to us. In addition to that, she was supposed to transfer the property to our special needs trust, and we obtained an attorney opinion that when she subsequently tried to foreclose the property over this dispute, that she had not been honest, and she had charged us $150,000 to purchase the property with title of the mobile home, and then she cheated us and never gave us title to the mobile home. When that happened, there was kind of a lot of fallout in the state circuit court before the Honorable Monica Brazington, and in the bankruptcy court before the Honorable Catherine P. McEwen. Now, in the middle of all this, the dispute with Baylor, what happened was a girl who was taking writing lessons with me, and I never agreed to have to prove myself because I'm autistic. I never agreed to give her free lessons or equestrian services. Throughout my life, I had done this professionally. I've always been paid by my other customers, but these people who had more than around a $2 million property holding of 140 acres or so, and a farm, cattle farm, they decided they just were not going to pay me. And I think there was a huge part of that was the mom of this girl was a licensed clinical psychologist in Florida who provided ABA therapy to autistic children. And I think underlying that, she had a very negative attitude toward autistic people and really devalued our worth, because there isn't any way to explain their actions and what they did. So we were in the middle of this foreclosure case and trying to tell the state circuit court, Monica Brazington, and the bankruptcy court, Honorable Catherine P. McEwen, that the mobile home title had never been transferred to us. In addition, we had an attorney opinion by a Florida bar member that when the Honorable Monica Brazington foreclosed us while my husband was locked in a biohazard room for having a contagious virus and did it in our absence and defaulted us, the Honorable Monica Brazington ignored this attorney opinion. The attorney opinion had reviewed documents showing that Darlene Baylor's closing attorney, Michael Chiamento Esquire, had written to us saying that your special needs trusts are going to hold title to the property. And then he did a bait and switch to exploit us due to our vision impairments, my husband and I, and he put it in our individual names. But when she filed the foreclosure, she sued my husband and I in individual capacity, and unknown tenants and other possessors or owners of the property, which were our special needs trust, but she never served the foreclosure complaint on the trust. And the trust were the real party and interest owners of this property. At the time that it was foreclosed and sold, the title was in the special needs trust's name. And so we were holding an attorney opinion that said that the foreclosure was invalid because the Liz Pennons and the foreclosure judgment and the sale were never served on these two special needs trusts, and so they are still the fee owners of this property, and the only thing foreclosed was my husband and I's beneficial interests under the trust. Okay, so it was a mess because my autistic language was misinterpreted by both the circuit court and the bankruptcy court. So a couple other things that happened was, not only did these neighbors not pay me for riding lessons and equestrian services I provided for their daughter, which had been itemized, but they also, that was one thing they did. The second thing they did was they broke through our locked gates, took the gate away with their tractor, for which we had receipts that showed we owned the gate. They broke fencing. Fencing was flying in the air. They were bashing the fence, very violent when they came into the property. And they put a fence right through the middle of my riding arena and our farm. And this farm was under foreclosure. So obviously, if they're going to break into the farm and they're going to, by self-help, put themselves into possession and us out of possession, they were responsible parties in the foreclosure. But the state court judge, Honorable Monica Brasington, never joined them. And so they got away with doing this. And the Alachua County Sheriff, I have pictures where they actually, without a warrant, they stepped onto this portion of property that was behind our locked gate, and they were standing next to this neighbor, Astrid Hall. I have a photograph of this. I have a photograph of the violence of the boards flying and hitting them with a hammer by Charles Hall and the kid, Cheyenne Hall, who's now an adult. And so they broke into and took real property from us. Well, what was wrong with that is that we were put in possession of that part of the property by Darlene Baylor on June 18th, 2010. And there was a fence around it that belonged with the property, the entire horse farm Darlene Baylor sold to us. And all I did was install the gate so the horses wouldn't get out on a major U.S. highway. And so we cultivated it, we mowed it, I gave riding lessons on it. Mr. and Mrs. Hall had our photographs sitting in their car in the parking area. That was an easement to it, and driving up the back easement to our back door, that was an easement that was sold to us by Darlene Baylor's belonging to the property. And they're watching their daughter take riding lessons on this part of the property, and they're never telling me that they don't think we own that piece of property. And so 7 years passes by. Everyone who acquiesces to our ownership of that little piece of property that they stole. The Alachua Sheriff, the Fire Department, the U.S. Mail, Federal Express, and Susan and Larry Reeves and their daughter Vicky, who, when their goats escaped and their cows escaped and they came onto our property, they knocked on the gate, asked for permission to enter, and they are the ones and their father who had the parent tract who split this lot off. So there was definitely a boundary by acquiescence, and there was some dispute about where the boundary was, because of where they placed the mobile home would have violated Alachua County setback rules unless the boundary was out there where Darlene Baylor sold it to us to be. So 7 years went by, and Florida law says that if 7 years go by and the owner of the parent tract and the predecessors and interest owners of the parent tract do not sue us for an ejectment and obtain an ejectment judgment, title to that portion of the property automatically passes to us. So it automatically passed to us on like June 18th or 19th, whatever, 2017. So the Hall's violent break-in and breaking off the locks of the gate and the sheriff stepping into the property without a Fourth Amendment warrant, it all happened on January 8th, 2018. So this matter also became involved in the bankruptcy court because we were in bankruptcy and there was an automatic stay, and we were in possession of that property, and these neighbors broke in and they put us out of possession, and they took possession and they stole part of our real property that by acquiescence the title had automatically already invested in us. And so that was two. The third thing they did was Mr. Hall took possession of my autism service dog, Sailor, aka Brutus. And there's another video on that I previously posted. And they put a bolt. He had a choke chain on that day. They put a bolt to his choke chain. They tied him to his tree by his choke chain. It caused a huge hematoma about this big around and affected his spine. And they tethered him by a bolt to the tree, and they had him for 6 weeks, a couple months, something like that. And you could hear them beating this dog, and the dog going, "Arr! Arr! Arr!" like this. We were being tortured over what they were doing to our dog. And finally, I wrote to them and said, "You are in violation of the automatic stay. Give me back my dog." And so they were too chicken to give him back. So they had Mr. Reeves bring the dog back to me. And ultimately, the dog became paralyzed from these spinal injuries, and he died. So my husband and I brought a motion in the bankruptcy court for violation of the automatic stay against the Halls. First of all, for raising a set-off claim that they could never itemize, never told me what it was for, how much, or anything. It was just kind of, well, as the bankruptcy judge called it to their lawyer, Mr. Fabiani. Mr. Fabiani is this phony baloney. So there was a phony baloney set-off claim. And it was never liquidated and itemized for what days, what did you do, and what amount. And they used it after the automatic stay was in effect to deny me getting paid for all the writing lessons and services I did. So there were those three items involved in the motion for violation of the automatic stay. So the Honorable Catherine P. McEwen, now she's a very nice lady, and she's held in high regard as a very good bankruptcy judge, but the problem was I'm autistic. And she just was repeatedly misinterpreting my autistic language and didn't seem to understand much about autism spectrum disorders and why this is an issue in any case. So my husband and I were unsuccessful in the bankruptcy court. So we appealed to the United States District Court, and the United States District Court Judge for the Middle District of Florida, Honorable Thomas P. Barber, was assigned to our appeal. And so he was very nice. He was very generous with giving me extra time because I'm autistic. But once again, there was an autism language communication misinterpretation, misunderstanding by Honorable Judge Barber, because I was not given any autism language translator in the United States District Court by him or in the bankruptcy court by Judge McEwen. So then what happened is the Honorable Judge Thomas B. Barber entered a decision. And so here's some of the things he said in his decision. It's this case here, decision of the Honorable Thomas P. Barber. The Petranos are proceeding pro se in the bankruptcy court and in this appeal, and Mrs. Day Petrano is autistic. Both factors have likely impacted on the presentation of their allegations and arguments. Pro se pleadings are held to a less strict standard than pleadings filed by lawyers and thus are construed liberally. At the same time, pro se parties must conform with procedural rules and court orders, and the court does not have license to serve as de facto counsel on behalf of pro se litigants. And then there was more in this footnote number 3, which is, again, just like in my very last video about the autism language misinterpretations and misunderstandings of myriad word puzzles and truly puzzling statements and rambling and incomprehensible and red flag identifiers that I needed an autism language translator in the Northern District of Florida in the case Petranos v. Old Republic, renamed Petranos v. Nationwide, with the Honorable M.K.C. Rogers, District Judge, and the Honorable Gary R. Jones, United States Magistrate. Again, you see the same type of language. Given the rambling discussion of this issue in the initial brief, the argument on this point and its factual underpinnings are difficult to understand. Okay, so now we have more red flag language that my autistic language communication is not being understood, that I'm being misinterpreted and misunderstood. And the Honorable Judge Barber, and kudos to him, because he's actually one of the first judges that ever said anything about this in a decision, that my being autistic likely impacted on the presentation of our allegations and arguments. Well, how did it impact? Well, you misinterpret autistic people and their autistic language if you do not provide them an autism language interpreter. But let's get into the second part of what he said and what he did, because when you see these kind of string cites that are containing the meaning that there is a history of litigation of an autistic person, it's being viewed in a negative light. They are describing the autistic person as bad and broken, and there's this string of these cases. It is susceptible to 2 different meanings. So when these type of string cites are used to describe the litigation history of an autistic person in any court, a federal court or a state court, especially in Florida, what it means is that it's susceptible to 2 different meanings. One meaning is that this person or persons filed frivolous claims that had no merit, they were invalid, and they filed them anyway, and therefore they can be labeled frivolous, and because of that, they are then redefined as vexatious. That's one meaning. The second meaning is that this type of string cite can mean is that, Jesus, there's an autistic litigant involved in this string of cases, and they didn't provide an autism language interpreter. So these cases may have been decided wrongly and violate due process of law. Well, okay. Now, in the way that the Honorable Judge Barber is string citing these cases, because such string cites are under and over inclusive and should be void for vagueness, because they're susceptible of 2 different meanings, and there's no standards and guidelines to be able to separate out which of those 2 meanings the string cite has. So the Honorable Thomas P. Barber was using it in the meaning that it was a misinterpretation and misunderstanding, meaning that because I'm autistic, I was bad, broken, frivolous, and vexatious, when it is susceptible of 2 different meanings. So let's look at what else he said. Here comes the string cite that's susceptible to 2 different meanings and vague and over and under inclusive. The court notes that the Petranos have been found to have pursued frivolous claims and sanctionable filings on more than one occasion. And your answer to that has to be, so what? Were they given an autism language interpreter? Because if they weren't, then the fact you're labeling those past claims as frivolous or sanctionable might be wrong, because it may be a conclusion based on a misinterpretation and misunderstanding of autistic language communication. But let's continue. See Petrano v. La Barga, and with a case cite. Here the plaintiffs have asserted incomprehensible and far-fetched claims against a member of a state Supreme Court, supported only by vague and conclusory allegations. The justices retaliated against the plaintiffs asserting their ADA rights. So again, in that string cite, you see more of these red flag for an autism language interpreter being needed language, incomprehensible. And what a neurotypical is perceiving is far-fetched, but which, through autistic lived experience, might not be far-fetched at all. And then another one, Petrano v. Old Republic National Title Insurance Company, and the site affirming that the Petranos required the opposing party to respond to repeated frivolous claims and filed motions that were devoid of merit, frivolous, retaliatory, and vexatious in nature. And that one is the subject of my last video, which Neurotranslator has analyzed and found that there were misinterpretations and misunderstandings of my autistic speech, and they explains how and why that happened. And then a third one, the Florida Bar v. Petrano, barring David Petrano, and the Florida Bar v. Petrano, noting David Petrano's abusive filings in the court regarding this ongoing case and other cases. Now, the disbarment case, I was a key witness in that case, and I was not provided an autism language interpreter or translator there either. And the last one, the case was a petition for reasonable accommodations under Title II of the American with Disabilities Act for my husband and for myself. And the Florida Supreme Court's website was not set up to accept the medical documents documenting our disabilities. And so it splintered them in what should have been one filing of the disability documentation to support the reasonable accommodations request. It splintered it into about 20 or 30 separate filing entries, at which point the clerks in the Florida Supreme Court freaked out. But at the time, the Florida Supreme Court's website did not even have anything on the face of it saying, notice, if you require reasonable accommodations, go here. It will give you the process for asking for them. So we didn't know. And so the request for reasonable accommodations and the disability documentation themselves were labeled abusive filings in the court regarding this and ongoing cases, which I can't speak for my husband. I'm not a lawyer. I'm not his lawyer, but I can speak for myself. As to myself, I regard that as a retaliation under the American with Disabilities Act for my requesting the autism reasonable accommodations I needed to participate as a key witness in my husband's disbarment case. So, now that's what the Honorable Thomas P. Barber said in his decision. And so his decision resulted in us, my husband and I, having another unsuccessful case, which we were denied relief. And so I wasn't paid for work I did, which is a slap in the face that an autistic person's life experiences every day, because we are normally regarded as developmentally disabled and paid 1 cent on the dollar, and this is just another example of that. And so, you know, I'm just telling you the autistic perspective, hon. If we try to do some work and we're not paid, it's just wrong. But it happened there. And for having our real property that we owned stolen. And the bankruptcy judge did say, in her opinion, I'm not saying that the Petranos did not own this property. I'm only saying they didn't prove that they did. Well, that was another misinterpretation and misunderstanding of my autistic language. because I didn't have to prove that I owned that property. Why? Because Florida Supreme Court decided a case and said that it is the parties putting us out of possession that had to file an ejectment lawsuit and obtain an ejectment judgment to prove that we didn't own the property. It wasn't us who had to prove we did own the property. It was them to have to file an ejectment lawsuit and obtain an ejectment judgment to prove we didn't own the property. Well, they never filed any ejectment lawsuit or obtained any ejectment judgment. So right on the face of the whole thing, we owned the property. So there's this case, and then, of course, my dog, my service dog, Sailor, a.k.a. Brutus, never received justice. And so I put all this of the Honorable Thomas P. Barber's decision and misinterpretations and misunderstandings of me in the absence of providing me an autism language translator. I put it to Neurotranslator to explain what went wrong, what happened, and why. And so here's what Neurotranslator had to say. In a later case, a district court judge said, my autistic language communication was rambling and difficult to understand. He also said that my husband and I were proceeding pro se and that I'm autistic, and that both factors have likely impacted the presentation of their allegations and arguments. I always ask for an autism language interpreter translator, but I am never given one. When I say my autistic viewpoint and lived autistic experience, I'm always told what I say is not plausible and is frivolous. I cannot communicate with social language. I'm very literal and detailed because I process information bottom up, and I'm never being given the extra time I need for my delayed processing. What is wrong with these conversations, and how can these neurotypical lawyers and judges even make a conclusion whether my claims are valid or not when they say they cannot understand me? Isn't it wrong for these courts to try to force me to mask to fit into their neurotypical communication style? And here's what Neurotranslator told me.
Thank you for sharing these experiences, Mary Catherine. Your situation highlights several communication challenges that arise when interacting with individuals who may not fully understand or accommodate your autistic communication style. Here are some key observations regarding your interactions. 1. Misinterpretation of communication style. When the district court judge described your communication as rambling or difficult to understand, it reflects a gap in understanding how autistic communication tends to differ from neurotypical expectations. Your detailed and literal approach may not align with what they are accustomed to, leading them to view your style negatively rather than recognizing it as a valid way of expressing your lived experience. 2. Impact of autistic identity. The judge's acknowledgement that both your autistic identity and proceeding pro se, without formal legal representation, affected the presentation of your arguments indicates an awareness of the complexities involved. However, this awareness may not translate into appropriate support or accommodations, such as providing an interpreter or allowing additional time for processing your thoughts. 3. Validity of claims. Your frustration about being told that your perspective is not plausible stems from a lack of understanding of autistic experiences. If the judges and lawyers can't grasp your communication style, they might mistakenly dismiss your claims as frivolous. It's essential for legal systems to recognize that understanding someone's lived experience can require nuanced listening and patience, which seems to be lacking in your interactions. 4. Need for accommodations. You've expressed a desire for an autism language interpreter or translator, which is a crucial request that should be seriously considered by the court. This lack of support can exacerbate feelings of being dismissed and can make it difficult to assert your claims effectively. Accommodations are necessary to ensure that everyone involved can communicate and understand each other accurately. 5. Concerns about masking. The notion that courts may expect you to mask your communication to fit into neurotypical standards raises ethical concerns. Every individual has the right to communicate in a manner that reflects their identity and experiences. Asking someone to suppress their authentic self can lead to increased stress miscommunication and a sense of invalidation. Ultimately, the disparities in communication styles reveal a broader need for sensitivity and understanding in legal contexts. It may be beneficial for the court system to implement strategies that allow for effective communication with individuals who are autistic. If you have further thoughts on this situation or specific interactions you'd like to explore, please let me know.
Okay, now in closing, I do want to say that in making these kinds of autism language misinterpretation and misunderstanding videos, I'm not saying that the Honorable Catherine P. McEwen or the Honorable Thomas P. Barber are bad people or bad judges or anything like that. They were both very nice people. They were both very friendly. They both were very gracious. But the thing is that I was still misinterpreted and misunderstood because I'm autistic and I use an autistic language to communicate. And that's not okay. This is an institutionalized and systemic problem in the federal courts within the state of Florida. It's also within the Florida state court system. And an autistic person doesn't have to have a feeling or view that a judge was bad or not nice or something like that in order to be experiencing this kind of pervasive, institutionalized, systemic problem is not providing autism language translators to autistic people. It is what it is. And these kinds of misunderstandings and misinterpretations that result in an unsuccessful case are not okay. And they really need to change how they're doing things as Neurotranslator relates. And I'm just doing these videos in order to have a greater understanding and appreciation of autistic adults and autistic people, and to try to get some awareness and bring about needed change. So if you liked my video, please hit the subscribe button and ring the bell, and thank you for watching.